Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Holly Owner presenting for us. If you are unfamiliar with the format of this event, first, Holly is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Holly will go over this in more detail, but please remember to keep your questions as general as possible as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Holly to get us started.
Thanks, Marissa. My name is Holly Owner. I am the practice group manager for the housing practice for Legal Aid of North Carolina. For those of you that don't know about Legal Aid of North Carolina, we are a statewide nonprofit law firm that provides free legal services in civil matters to low-income people. This includes child custody, criminal record expungement, Medicaid rights and eligibility, simple divorce, SNAP benefits, Social Security disability, tenant rights, and wills and power of attorneys. Today, we're going to go over landlord-tenant law. We'll talk about what it means to be a tenant, the eviction process, if you have any kind of habitability conditions in your home, and briefly about security deposits. So in order to understand the rights of tenants, you need to understand who is a tenant. And a tenancy is created when two parties agree to exchange, two parties agree to enter into a lease. In North Carolina, the lease doesn't have to be in writing, but there has to be some kind of terms of the lease, usually that the landlord is offering a place to stay and the tenant is offering money to stay there. North Carolina does have some laws around tenant protections when the tenant is living in a hotel or motel. So when a landlord wants to remove a tenant from the home, in North Carolina, they must go through the legal process. If a landlord is to try to remove a tenant without going through the court process, we call that an illegal self-help eviction. The first thing that a landlord typically does to initiate the eviction process or trying to get a tenant out of the home is to send a notice. Oftentimes that notice is in writing and has to comply with certain laws. And after the notice is sent, if the tenant continues to stay in the home, then the landlord will file a lawsuit against the tenant. So the tenant will typically receive two documents posted on their door or delivered by a sheriff. The two documents are a complaint and a summons. Typically, they are going to be like yellow. The paper will be yellow. Not always, but a lot of times. So the complaint includes why the landlord is filing the lawsuit. And the summons includes the date and the time and the place where the hearing is going to be heard. The hearings are almost always in small claims court in front of a magistrate, which is what we call the judge in small claims court. So there are four reasons why a landlord can file an eviction case. And this is a copy on the right here of what the complaint looks like and the four reasons or the four grounds that a landlord may have to bring an eviction action are indicated by the boxes that are circled on this slide. The first is that the defendant failed to pay rent. The second is that the defendant or tenant stayed after the lease expired. The third is that the tenant breached one of the terms of the lease. Oops, sorry. And the fourth is that the tenant committed some type of criminal activity. So the landlord has to prove that one of those things happened in order to win the eviction case. Important to note that simply having an eviction filed against a tenant becomes a public record. And even if the case is ultimately dismissed, the filing itself is public. There's no way to expunge an eviction case in North Carolina at this point. So if a landlord is filing under the first box, the non-payment ground, then the landlord has to prove that the tenant failed to pay rent on time and that the landlord has made a clear demand for the rent and then waited a 10-day grace period before filing the eviction. Oftentimes, by law, a tenant can pay what they owe plus court costs in order to stop an eviction this way. The next ground or the next box on the complaint is what we call holdover, which means that the lease ended and the tenant continued living there. And this can be a little confusing sometimes because many leases have built in that at the end of the initial term, the lease automatically becomes a month-to-month lease. So, for example, if I am a tenant and I sign a lease on July 1st of 2024 and it expires on June 30th of 2025, but I continue staying after June 30th of 2025 and I continue to pay rent July 2025, August 2025, and my landlord continues to accept that rent, that's not considered a holdover. That just means that the lease, even if we haven't signed a new lease, that means that the first lease that was signed, the year-long lease, just continues to operate each month that I pay. But if the landlord gives notice before the end of the lease term that they no longer want to, they don't want to renew the lease, they no longer want to rent to the tenant, and the tenant receives that notice and continues to stay, in that situation, the landlord has the right to file an eviction based on this ground holdover. If the lease does not, usually the lease will say how much notice is required in order for the landlord to file an eviction. But if it doesn't say that, then the law says that the landlord must give 30 days notice if it's a year-long lease, 7 days notice if it's a month-long lease, and 2 days notice if it's a week-long lease. If the landlord gives notice that they are going to end the lease, but then the tenant pays rent after that and the landlord accepts it, then that notice becomes void and then that month-to-month lease sort of continues. The third ground or the third box is that the landlord has alleged that the tenant has breached a term of the lease. So an example of this might be if your lease says you're not allowed to have a dog, but the tenant's not allowed to have a dog, but the tenant, there's some kind of evidence that the tenant has a dog, then the landlord could file an eviction action based on the tenant breaking that rule or breaching that lease term of not having a dog. But another common example of breach of lease can also be non-payment. So there's two ways that a landlord can file to evict a tenant for non-payment. The first box or this one, because many leases, a term of the lease is that the tenant has to pay their rent. And if the tenant doesn't pay their rent, then that's a breach of that lease term. There is a section of the complaint that says description of breach, and so the landlord is required to indicate what they're alleging the tenant has done as a breach of the lease. Then the last ground is criminal activity. And so there's certain things, it has to be a violation of the North Carolina Controlled Substances Act or other criminal activity that threatens the health, safety, or right of peaceful enjoyment. And so if the landlord is alleging that the tenant has committed some type of drug crime or has committed some other type of crime that threatens the health, safety, or right of the landlord or other tenants, then the landlord can file an eviction based on that ground. A tenant can be held responsible for the actions of other household members or even their guests, but there are ways for the tenant to be able to have that person, the other household member or the guest, removed or evicted without the tenant being evicted. That's something that the tenant could ask the court to do if the tenant is facing eviction for this. So there's lots of ways that a tenant can defend against an eviction. And so the most important thing is that if you are a tenant who's facing eviction, you should call legal aid and see if you're eligible to have a lawyer provide you advice or perhaps go to court and represent you in court. Our services are all free. But some of the ways that tenant can fight against the eviction is if the eviction is based on the tenant being a victim of domestic violence, then the landlord, that's not a ground that the landlord can evict a tenant based on. So that's something that we would raise as a defense to try to fight against the eviction. If the landlord is alleging that the tenant breached the lease term, but the landlord somehow allowed the tenant to do that, agreed for the tenant to do that. In my situation, hypothetical earlier, where the lease says the tenant cannot have a dog. Well, if the tenant speaks to the landlord and says, "I'd like to get a dog. Is it okay if I have a dog?" Or the landlord knows about the dog and the tenant continues to pay rent and the landlord continues to accept rent even though they know about this breach, that could be a defense called waiver. There are lots of ways, sort of different legal arguments related to waiver for both the landlord and the tenant. Another defense that the tenant may have in an eviction case is if the landlord did not provide notice or did not provide the proper notice. And that again is defined by the lease, by the law, or if you're a tenant in subsidized housing or public housing, then there's certain requirements of how that notice needs to look. And if the landlord does not provide the proper notice, that could be another defense. If the landlord fails to offer a reasonable accommodation, that's a requirement under the Fair Housing Act. And so that could be a way to defend against an eviction. If the landlord is claiming some kind of money that they're not actually entitled to, that of course is a defense. The landlord must also make a demand for possession of the home after giving notice and before filing. That's another one of the um, elements on the complaint. And if they fail to do that, that could be a defense. Um, and then there's some other defenses if the landlord is claiming criminal activity. And of course, this is not an exhaustive list. These are just some. So after the sheriff serves the lawsuit, the complaint, and the summons, then the hearing will happen, usually within a few days or weeks from receiving uh, the summons and complaint. And that hearing typically happens in small claims court. It's important to show up early because you don't want your case to be heard without you being present. Um, and the first thing that happens is that the landlord presents his or her case. And so, again, the burden is on the landlord to meet all the elements of their case. The landlord provides testimony and evidence to the magistrate about why they're asking for the eviction. They can call witnesses. The tenant can cross-examine the witnesses. And after the landlord is finished presenting his or her case, the tenant then gets the opportunity to present their case. And so, again, they can testify, provide exhibits or evidence, call witnesses. And at the end of both sides having the opportunity to present their case, the magistrate will make a decision. There are four different decisions that the magistrate can make. The first is the magistrate can grant the eviction for the landlord. That's typically called entering a judgment for possession. The second is that the um, magistrate can dismiss the eviction case. The third is that the magistrate can continue the case to another date. And the fourth is that the magistrate can reserve their judgment or not decide right away. That's not so common, that fourth one. Um, After the magistrate gives their judgment, there is a 10-day appeal window. So if you hear a magistrate say, you have 10 days to work something out with your landlord. You have 10 if they're awarding a judgment for possession. Or if they say, you have 10 days to move out. You have 10 days to comply with my order. What they actually mean is you have 10 days to file an appeal. And either party can file the appeal if they've lost. So if the magistrate dismisses the case, the landlord has 10 days to file an appeal. And if the magistrate grants the eviction, then the tenant has 10 days to file an appeal. If the magistrate grants the eviction or enters a judgment for possession, those mean the same thing, then the tenant can file an appeal and stay in the home while the appeal is pending if they pay their rent to the clerk during those 10 days and moving forward. That's called a rent bond. The amount that they pay to the court is called a rent bond. And if they do that, then the tenant can stay in the home, continue paying their rent as it comes due to the clerk while the appeal is pending. The appeal is heard then in district court, and the whole process starts over before a judge in district court, where the landlord presents first, then the tenant presents, and then the judge decides based on a whole fresh hearing in district court. There was a change to the law recently, which now requires that if the tenant does not appear in small claims court or does not raise a defense in small claims court, then the tenant must appeal and then file what's called an answer in order to keep their appeal alive in district court or a counterclaim, which is like a counter lawsuit. So if the tenant does not, if the tenant loses in small claims court, does not appeal within the 10 days, then the next step of the landlord removing the tenant from the home is that the landlord needs to appear in the clerk's office on the 11th day or later and request what's called a writ of possession, which is also known as padlocking papers. And the clerk confirms that the tenant did not appeal, that the landlord is entitled to the padlocking, and then sends the writ of possession to the sheriff. That takes about another week before the sheriff goes out to the home to actually physically remove the tenant from the home and have the landlord change the locks. Um, so the landlord cannot change the locks themselves without getting this document and getting the sheriff to come and be present during that. The tenant then has about a week to go back and get his or her belongings. But in order to do that, the tenant needs to coordinate with the sheriff and the landlord to go back to get their belongings. So that's the everything to know basically about the eviction process. Now we're going to move to the landlord's duty to make repairs. So the law says that landlords have a duty to keep their homes or their units that they're renting out in a fit and habitable condition. That means that the landlord must obey any local housing code. So many cities and towns have a local housing code in addition to the state statute. The landlord must repair dangerous conditions in a reasonable time, keep common areas safe, keep electrical, plumbing, sanitary, heating, and other facilities and appliances in a good and safe working order, install smoke and carbon monoxide detectors. And these are just some of the things that are included in the statute about what a landlord has to do to keep the home habitable. These duties cannot be waived by the landlord. That means that the landlord can't tell the tenant you're agreeing to rent this home as is. That those are illegal. The landlord can't say, well, the tenant knew that the home didn't have heat in the winter and agreed to live in it anyway. That doesn't absolve the landlord of liability. The tenant, if they're experiencing these kinds of issues with the home, must first sort of document what the issues are, take pictures, take videos, request from the landlord, notify the landlord and request repairs, and then continue to pay rent as they're experiencing these kinds of issues. However, the law says that the tenant is entitled to rent abatement, or in other words, a refund of rent for the months that the tenant paid rent when the home was not habitable. So if the rent stated in the lease is $1,000 a month, but the agreement between the landlord and the tenant is that that's $1,000 a month for a habitable home, for a home that is in good condition. If the home isn't, then it's not actually worth $1,000 a month. And so the tenant has to sort of assert that a home without heat in the winter is actually worth less. And that is dependent on the facts and circumstances of the particular case. And so, again, if a tenant is experiencing these kinds of conditions, they should document them. They must notify the landlord and ask that the landlord make repairs. They can also contact their local code enforcement department for a free inspection. And if the landlord continues not to make repairs, then the tenant can file a lawsuit against the landlord for money back for not making the requisite repairs. Or if the tenant stops paying rent and the landlord files an eviction against the tenant can then countersue or counterclaim for money back, or essentially say, no, I didn't pay rent last month for $1,000, but that's because for the last um, 3 months, my home has really only been worth $500 because I've lived with these conditions that the landlord hasn't fixed. So actually, I'm owed $1,000 back, and it sort of cancels out. If a tenant wants to file their own lawsuit against the landlord, then the tenant can file that suit in small claims court, but cannot ask for more than $10,000. If the tenant believes that he or she is owed more than $10,000, then they must file in district court. The tenant can use an indigency petition, which is like a court form, to avoid paying the filing fee if they are deemed indigent, which means that um, they make under a certain threshold. They have their income is under a certain threshold. So if the tenant is trying to argue that they have been the victim of conditions issues, or that they've lived in an uninhabitable home, whether they're filing their own suit or filing a countersuit, the type of evidence that the tenant would want to share with the court about that are going to be pictures of the issues, video footage of the issues, um, texts or emails or work orders where they have notified the landlord of the issues and requested repairs. Also, you might want to show code inspection reports or call the code enforcement inspector as a witness, because that person is an expert in what it means for the home to be habitable. And they can testify about having gone to the home and what conditions they saw. This slide explains that the money that the tenant can receive in a um, case for habitability is the difference between what the rent was in the lease and what the rent should have been given the conditions. That's what I described earlier as the difference between like 1,000 and 500, for example. And then the tenant can also ask for damages if they've had to spend money on a space heater, if they've had increased utility bills, if they've had to stay in a hotel because they couldn't stay in their own home, or other kinds of money that the tenant has paid as a result of the conditions. And the tenant can also ask in situations where the facts are really extreme and the landlord's conduct is really egregious, the tenant can ask that their damages actually be tripled. Typically, the tenant is bound by the terms of the lease. If you've signed a year-long lease, you have to stay in the home for a year. If you want to break the lease early, most leases describe what the penalty is for that. You have to pay a certain amount of money to get out of the lease. There is an exception for victims of domestic violence. But in that situation, the victim of the domestic violence needs to get specific documentation from either the prosecutor's office, the police, or a domestic violence organization or shelter, and give the landlord a 30-day notice in writing explaining that they're breaking their lease because they're the victim of domestic violence, and sharing that specific documentation. The landlord does, however, have a duty to try to put somebody else in the unit to mitigate their damages. And so finally, security deposits. The law is pretty specific about how security deposits need to be handled. Um, the landlord must return the security deposit after 30 days or else provide an uh, request for an extension of an additional 30 days. And then by this, if they request an extension, then by the end of the 60 days, they must return it or give an accounting about what they're using the money for if they're not going to return it. There's very particular things that a landlord can use the security deposit for. And it can't just be normal wear and tear or repair of normal wear and tear. When the tenant is moving out, the tenant should document the condition of the home as they left it to show that it was in good condition. The lease has to identify the bank where the security deposit is going to be held. And if a landlord does not abide by the rules and the statute around security deposits, then the tenant can sue the landlord in small claims court for that money to be returned. It's important to say that if the tenant does sue the landlord asking for the money to be returned, the landlord can always countersue if the landlord has reason to believe that they are entitled to money. And so it's always important if you are going to initiate a lawsuit, no matter why you're initiating the lawsuit, to assess what your risks are in being countersued. So that's sort of the basics of landlord-tenant law, and I'm happy to answer questions.
Awesome. And so if you have a question, you either need to type it in the Q&A box on Zoom or put it in the comment section on Facebook. You cannot unmute in this forum. So if you have a question, you need to type it in one of those two places. I'm not seeing any questions at the moment, but gonna give it just a few seconds here to see if any questions do come in. And also, just for everyone's reference, I did put a link to Legal Aid of North Carolina's Eviction Defense Manual into the chat box on Zoom and the comment section on Facebook if you want to learn more about some of those common defenses that Holly mentioned and just more information about the eviction process in general. All right. As I have not seen any questions, I'm going to go ahead and say thank you to all of you for joining us, with a special thank you to Holly for that wonderful presentation. If you'd like to review anything that was discussed today, we have posted a recording of today's event to our Facebook page. Oh, wait, spoke to someone? In a situation where a landlord is refusing to acknowledge a pest issue, would it be a good idea for the tenant to reach out to code enforcement? A tenant doesn't want to potentially, initiate any retaliation from the landlord. So kind of what are the risks with reaching out to code enforcement?
Um, Pests are another one of those things that are listed in the statute around making sure a home is habitable, and that is a thing that code enforcement officers are trained in identifying. Um, it's impossible to know if the landlord will try to retaliate. If the tenant is in a year-long lease and the tenant is paying their rent, then there shouldn't be any and has not committed any crime or otherwise breached the lease, there shouldn't be any ground that the landlord could file an eviction against the tenant for. But frequently, tenants are in month-to-month leases. And so if the tenant calls code enforcement and code enforcement finds that there's some kind of issue, um, and the landlord doesn't want to repair it and would rather just give the tenant notice that they're not going to renew the lease and then evict for holdover, there's no like assurance I could give a tenant in that situation that the landlord won't do that. Um, I, I think it's up to the tenant if they want to take that risk. I mean, no tenant should have to live in a home that's has any kind of infestation. An infestation can and often is considered an uninhabitable home. And so I would encourage any tenant in that situation certainly to reach out to legal aid and discuss kind of um, the risks and benefits with a lawyer. But and then again, if the tenant does reach out to code enforcement, reaching out to code enforcement is not going to be confidential. So as soon as the tenant reaches out to code enforcement is going to come out, make an assessment, and then if they find violations, they're going to reach out to the landlord and say, "We found these violations, and you need to make repairs." Um, does that answer the question?
I think it does. And for those interested in potentially having a case assessed by legal aid, Holly has put up the information to get in contact with legal aid. Um, just be aware legal aid does have eligibility requirements. Okay. And so, again, if you would like to review any of this information that was discussed, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access the recording with or without a Facebook account at www.facebook.com/legalaidnc. And then in about a week, you will be able to access this recording at any time on Legal Aid of North Carolina's YouTube page. If you would like to register for one of our other listen and learns that Holly mentioned, such as Medicaid rights, child custody, simple divorce, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their afternoon.